group effort to find out from lawyers what they were experiencing with mediation. And we had a series of focus group meetings, usually about 10 people each, taking an hour and a half to 2 hours each from different fields of law, including family law, land use law, employment law, trust and estate law, elder law, collaborative law, a whole number of them, construction. And a common theme emerged. One of the themes that emerged was there was a very high level of satisfaction with mediation. Lawyers like the process. It gets cases settled. A second theme emerged is that a lot of lawyers wanted to break into mediation. They expressed that desire. They wanted to grow their mediation practices, either expand the way they were mediating cases or become mediators themselves. And the third theme that emerged is it's very hard to break in as a mediator. They just ran into it's just hard to break in. How do you get clients? How do you get people to hire you as a mediator when there's so many good mediators out there that seem to have all the business locked up? So that came from the focus groups. Right around that time, I think it was the state bar ADR section. Remember, we're working in concert with the county bar ADR section. Embarked on a study. We actually hired a surveyor, a researcher, a recent law graduate, to interview 25 prominent mediators and also some attorneys using mediation throughout the Northwest and identify what mediators are doing. So we didn't know what the survey would show, but the survey showed a number of things, 3 things. One, again, a high level of satisfaction with the mediation process, both from the mediators and the lawyers that were interviewed. The second thing is that most of the mediations that occurred, and this came from the mediators, occurred toward the end of the case, what we call the summit conference at the end of the case. After discovery, before trial, sometimes immediately before trial, sometimes a little ways before trial, but usually late in the case. And a third theme that emerged is that there was a small number of lawyers and mediators that had experience with early mediation, mediating a case much closer to when the case emerged rather than late in the discovery process. A fourth thing that emerged from the conversation with mediators, and this was a very surprising one to me, is that half of the mediators, a full half of them, very frequently or routinely would have communication with the lawyers that they were mediating the cases for, other than, before the mediation itself, before they bring people together, the communication would be other than a letter from the lawyer outlining the case. In other words, they either had a phone call, sometimes a meeting with the lawyers and the parties, sometimes a phone call with the lawyers and the parties, but there would be some heads up that the mediators would get from the lawyers before coming to the mediation table. And that was pretty significant because 10, 15 years ago, that was viewed as an innovation, something that didn't happen very often. And our survey showed that it was happening now. Half the mediators were doing it. That means half weren't doing it, but half were. So we got that research. In a parallel universe, but independent and separate, the State Bar Association, about 5 years ago, put together a task force. And this task force was called the Escalating Costs of Civil Litigation Task Force, or the task force, ECCL, Escalating Costs of Civil Litigation Task Force. Their purpose was solely to examine why is litigation so expensive? What can we do to lessen the cost? This is the Bar Association coming up with this. It's not from the world of ADR. There were some ADR people on it, but most of it were litigators. Now, to be clear, they excluded family law from this. And the reason they did that is they basically looked at themselves and said, we're mostly commercial litigators. The family law lawyers are going to have their own concerns, so we're not going to include family law, although from my observation, everything that they came up with probably applies to family law as well. They invited the ADR section to participate as a sort of give us some recommendations on how ADR fits in the equation. So what we did is we took the survey of mediators, And we took the comments from the lawyers, and we took the gatherings from the focus group, and we came up with 3 recommendations. And the 3 recommendations were, 1, since mediation is used in literally every case, imagine that. Most cases settle, all cases are mediated. You can't get to court in federal court or state court without going through a mediation first. Since every case is mediated, you can't mediate more. There is no more to mediate. Every case is mediated right now. If you want to save money, it's very, very simple. Instead of mediating here, this is a timeline. Cases filed, discovery, go to court. Instead of mediating here right before you go to court, you mediate earlier. Just move that time. That's early mediation. It's as simple as that. The second recommendation we made is that to consider in mediation, in whether you mediate at the end or earlier, some communication with the lawyer, with the mediator, between the lawyers and the mediator, to set up the mediation a little bit more effectively. It can create some efficiency. You can negotiate discovery. What information do you need before you come to the table? What information do you want to provide before you come to the table? So that was the second aspect of the recommendations, is to build in that innovation, what used to be an innovation, but now half the mediators are doing it. And the third thing, and this was the sort of more conceptual part of this, is to consider mediation earlier. Just move it back in time. Well, that's similar to the first thing. Consider early mediation, and then when you consider early mediation, even go earlier. We're grateful for the response we got from the ECCL task force. They accepted our mediations. They accepted our recommendations. They not only accepted them, but they passed them on. They wrote them up in their own way, and the recommendations were approved by the Board of Governors very recently, I think last month or so. It's now going to the Supreme Court, where we anticipate it'll be approved by the Supreme Court. What that leaves us with, and I want you to sort of absorb this, because this was a big thing for me, working in this field for 30 years. We have the Bar Association now. I don't know any bar association that says this. We have the Supreme Court of the state of Washington, they haven't said it yet, but I anticipate they will, saying early mediation is a swell idea, and you could save money doing it. This is the lawyers telling the world that. It's telling the lawyers that too. It's telling the mediators that. I think that's as good as a great AVO-REC recommendation. I mean, these are things that we have now that we could take with us to our clients and say, we have official endorsement. It's very similar to, it's like organic farming or physicians recommending good nutrition. And in all the other things they do, they recommend good nutrition too, and sleep better. So we have that going for us. I wanted to add one thing. We have the research that shows that these practices work. We have the official endorsement. I want to add one more part to what I wanted to share with you, and that is what's in it for us, what's in it for the mediators. Of course, early mediation, remember, there's not more cases mediating. The same number of cases are going to be mediated. Well, maybe a little more, because there's a lot of legal disputes that aren't filed as lawsuits. But what was really in it, I was reflecting on raising my child and a similarity that showed up. And one of the things that, when I think about those favorite moments of parenting, I think about that aha moment. I mean, the wonderful moments include the, huggy stuff and the I love you, and that happens now and again, but those aren't the favorite moments. Those aren't on the day-to-day. The day-to-day favorite moments are when the child reaches that moment of, oh yeah. I have an example. We're at a baseball game, and I have these seats where occasionally the players come off and throw a ball to the little kids in that section right behind first base. My son has caught a number of balls over the years. So one game we're there, and he's got a friend, and he catches a ball, and on the way home I say to him, why don't you consider giving that ball to your friend? And of course he said, why? And I said, well, because he'll be real happy to receive it, And if you do that stuff, if you have a generosity of spirit, you give stuff away, it comes back. It comes back in ways you'll never know. So he thought of it. Anyway, he gave the ball to his friend on the ride home, and the friend was ecstatic. And his dad thought I was a swell guy, and everything went perfect. And on the way home, I was able to say to my son, "So how'd that work?" And he said, "Yeah, it worked really well." He was really happy, and so I just sort of let it go. So 3 months later, there's a bobblehead night for a Hall of Fame guy. And I get there, first 20,000 seats, you get a bobblehead, so I get there at 5:30. It was later than, the game starts at 7, 5:30, too late by a half hour, no bobblehead. It's like, what am I going to do about this? There's eBay or something. And I thought, okay, I'll do the 2 tickets for the Grateful Dead, so I asked for a miracle. So I put a little note on my paper plate, anybody want to sell their bobblehead? 2 innings later, I'm in a line at one of the concessions, and a guy comes up to me and says, "Is that your kid?" I said, "Yeah." And he hands me a bobblehead. So on the way home, I'm able to say to my son, "Remember that conversation we had a few months ago about generosity of spirit and when you gave that ball away?" And he looked at me and he went, "Oh yeah." So that "oh yeah" moment. So I thought about that. And all this came to me about 3 weeks ago when I was putting this, what am I going to say tonight? I thought, that's exactly what I get in mediation. That's why I do it. That's my motivation, to create those oh yeah moments. That's why I've been doing this for 30 years. And when I started, I had oh yeah moments practicing law, representing clients, a few, but I had a lot of screw you moments, go sit on a stick moments, over my dead body moments. And a lot of walking out of court with God, what was that about moments? There weren't a lot of oh yeah moments, but when I started mediating, it was all oh yeah moments. And I thought, what are the qualities of the great oh yeah moments? It's a conversation I have with people in private, where they come to their own sense about the situation. It's not me figuring it out what their dispute is. It's them figuring out their own way and finding their way out of it. And then I kind of disappear in the background. The process kind of disappears. Those are the oh yeah moments that we have. And I think what's in it for us when we talk about early mediation, before the families have been destroyed by the discovery about all the bad things that happen, or all the money that's been stolen by one side or the other, before all that happens in a litigation, if we could catch people, we can give them the opportunities to find their own oh yeah moments. There's a lot of ways to describe that last point. What happens in typical lawsuit mediation is by the time it gets to the mediator, those issues are totally teed up. There's 4 issues that are going to be tried. There's 3 issues that there's some dispute about. And the lawyers have a real good articulation of why they're going to win on these issues. And the real point of the dispute is lost somewhere. And the lawyers aren't even talking about that. And that's no fault of lawyers, because the judges don't want to hear it. The juries aren't going to rule on that. And it's very challenging to get people back to what the real problem is when we've got all these legal issues that have to be sorted out. So if we could catch things earlier. We've all seen this metaphor about mediation. You're on a freeway to the courthouse, and when you're mediating, you're going on an off-ramp. And if you can settle the case, you don't have to get back on that freeway. You can just go home. And if you don't settle the case, you get back on the freeway and nothing's lost. That's the old way of mediating, when you're mediating at the end of the case. If we can get on that off-ramp real early, even before they get on the freeway, that creates opportunities for those oh yeah moments. So I want to close with just a big wrap. We started with talking to lawyers about what's going on in the field of mediation. We found out that there's a very high level of acceptance to mediation. It hasn't always been this way. That was a paradigm shift. We talked about the survey of mediators, where the mediators are starting to mediate early, and they have these range of practices. Instead of bringing everybody together, which is kind of hard to do anyway, just scheduling 6 weeks out, we're having a meeting here and a meeting there, just shuttling back and forth. That could be done on a very subtle level, on literally any case, just to sort out the discovery. We've talked about the Bar Association looking at these practices and say, those are some swell ideas. And we have been using them and endorsing them. And now we have the ability to go out and articulate what this early mediation is. We're part of a big movement. It's happening. It's not conceptual. It's not maybe it's a good idea, try it. We're talking about repeating things that have already been occurring. So my call to you is, if there's any part of what I've said that you kind of identify with or resonate to, or that you think, yeah, that's exactly what I want to do, or I do well, and you want it to grow, then cultivate it. I think the next step is for the fields themselves to identify what early mediation is, which means the family law lawyers will tell us what early mediation is in family law. The employment lawyers will identify it in employment law, the construction lawyers. And the shift that I'm seeing will be that we can all become mediation forces. Some of us will be mediators, some of us will be lawyers representing people in mediation, advisors, and it doesn't require the authority figures that are often favored, the former judges. It just simply requires the ability to speak the same language as the people coming to mediation, encouraging millennial young lawyers that want quick action and quick settlement and don't want to be supporting large litigation like has occurred in the past, encouraging them to try mediation, sort out matters that can be sorted out. That's it. I want to then have Paul say a few words and have Roger say a few words about things that are currently happening in their fields. Thank you. You're talking about early mediation and family law and child-centered disputes.
You will see that I did not spend nearly as much time thinking about what I'm going to say this evening as Alan did. I've been asked to just say a little bit about early mediation in family law and what's been happening. It's been happening for a long time. I remember a very early panel I was on, the KCBA family law section had a panel about how they do things in other states. And one of the things I mentioned was including children in mediation. And I heard a shriek from the back of the room, "My God, you cannot do that." And I said, well, as a matter of fact, a lot of places they do that. At the recent AFCC conference that was here, the National AFCC, Association of Family Courts and Conciliation, if you're not familiar with the AFCC, had their national conference here this year. It's one of the best educational conferences I think that anybody puts on. The AFCC does a marvelous job. Not to discount what the ADR section does or other groups do. But it's a 5-day kind of education thing, and they had like 7 or 8 different presentations on child-inclusive, child-focused mediation in family law. So change is slow, but it happens. I only have about 30 seconds left. So there's been some legislation that was introduced in the state of Washington about 3 to 4 years ago, mandating early mediation in family law only in parenting cases. That never went anyplace. There may be a revival of it. There's some interest in it. It's kind of been on the back burner, but with the legislative session coming up, who knows? The KCBA, the King County Bar, or not the bar, the King County Judiciary decided to put together a little committee looking at ADR, and Kathleen is on the committee, as a number of other family law practitioners, people who are active in the KCBA ADR section and family law section. And it's it's just moving it up early on the case schedule, mandatory disclosure in the terms of discovery, and other things. So it's moving forward. There's a lot of discussion about it. I'm glad to answer any questions or talk to anybody. I can talk for hours about it if you want. And my time's up, so I'll turn it over to Roger.
I'm an old radio guy, so I prefer to give you my voice and hold my image, but what can I say? My name's Roger Moss, and it's a pleasure to be here. Thank you, Alan and Craig, for giving me this opportunity to say hello. I'm a part-time employee at the King County Bar Association since April, supporting the lawyer referral service and working on an ADR project that I'm here to tell you a little bit more about. But first, I want to invite everyone who's available to come down to the October KCBA ADR section meeting. It's going to be a mixer on October 20th at the Fifth Avenue offices from 5 to 7 p.m. And it's going to be a celebration of the worldwide ADR awareness festivities that are happening all over the planet. And it's going to be a time for us all to get together and have a drink and break bread and talk about ideas and about the future. And as part of that, we're going to be softly rolling out the first elements of this new project, which are going to be new mediation and arbitration panels that will be operated as part of the KCBA Lawyer Referral Service architecture. These panels are part of a much bigger idea that has been under development since the beginning of the year with a very dynamic group, which Alan has led, sort of an ad hoc committee of the ADR section members, asking the questions that Adrienne so beautifully wrote about in the May KCBA Bar Bulletin. What is ADR really? How do we challenge our own practices in the context of the ECCL findings? Where do we go from here? And so we're going to build a platform that is very robust, it's interdisciplinary, and it's going to cover everything from marketing to getting business to our mediators. And the mission is very simple: build awareness in the community of alternative dispute resolution practices, conflict management tools, and support the business plans of our providers. So come down and see us on October 20th. Thank you.
Thank you. We're running a little late, so I will give you somewhat of a truncated version of the presentation I was going to make, so that you can avail yourself of the hosted bar. Free. Yeah, free drinks. Since we have a limited number of individuals in the room, the section can afford it. I wanted to briefly, and this is sort of food for thought, if you will, in the area of ADR and arbitration. The first one, ADR, thinking outside the box. This topic came up when I was doing a seminar on the other side of the world on construction law. And I used to be an advocate, and I represented a big construction law company here, or a big construction company here in Seattle back in the late 80s. And the way construction companies used to do business is a little different than they do now. But I remember I had a client, this client come in, and he came into my office and he started telling me about all the things that they had done wrong. And I go, oh, well, that's not good. And then after telling me all these things that they had done wrong, I said, so do you want to make an offer of settlement? Do you want to go into mediation? And he kind of looked at me like, are you crazy? I want to sue them. And I go, you want to sue them after you told me all those things that you screwed up on? and that was sort of the way it used to be. It was the preemptive strike, the iron, hammer that you would be the first one to utilize. Well, construction law turns out to be in the forefront of ADR. Just because you have these big mega projects oftentimes, and even if they're not mega projects, they're smaller projects, you got to keep them going. You got to keep them moving. So the construction law area started developing methodologies for keeping the process going and keeping the project going. Okay. This is just part of the steps that the construction law sort of evolved into. They recognize that the best way to deal with disputes is not to have them in the first place. So they put a lot of effort into avoidance and prevention. And they do that through things like partnering arrangements. And a lot of things you learn from the construction area can be applied in other industries. Communication, a well-written contract. But a lot of the avoidance has to do more with the culture and psychology than it does with law. Having these meetings, these partnering meetings, having a commitment that you're going to work together between you and the subs and that sort of thing. And then you'd have the step negotiations. And when I say step negotiations, you'd start out with the parties who are kind of at the lower level trying to resolve it. And if they can't resolve it, it goes to the supervisor. And then it goes to the next level. And there's a built-in incentive that the individuals at the lower level don't let it go to the next level because they're going to get in trouble. So they try to resolve it at the lower levels. And then you have this whole concept of standing neutrals, where you have an engineer or somebody who's not associated with either side who gives an opinion right away on how this should be resolved and maybe reserves the ultimate resolution of it until after the whole process is done. The same with the Dispute Resolution Board, the DERB, or the Dispute Adjudication Board that you run into in Europe. And then you move into mediation. And then you move into arbitration. And then you move into litigation. And all along, of course, there's negotiation. But a lot of effort, and the point I'm trying to make here is that you want to look at your clients and your industry, because when I started practicing law, you only had a couple options. You negotiated or you litigated. Then you negotiated and maybe you mediated and litigated. And then maybe you negotiated, you mediated, and you arbitrated and you litigated. But then there are other things that can be done in order to avoid the disputes in the first instance and to resolve these things short of all the heartache and costs and time consumption of arbitration and litigation especially. Okay, that's all I wanted to say about that. Making the most of your arbitration. Arbitration, of course, has come in for a lot of criticism lately because it's become very much like litigation. The argument is that, why should I arbitrate? Takes as long, costs as much or more money. It's not the great, economy, economic situation that it used to be, that it was touted to be. Well, a lot of that has to do with a couple of things. One are the advocates involved and the arbitrators involved. And this is a list of what I consider to be some of the key suggestions to making your arbitration cheaper and faster and more efficient. If you've got an arbitration clause that you're negotiating, tailor it to the situation. And there are books written on this, the kinds of issues that should go into an arbitration clause, assuming you can do that. The other is the individual who's negotiating the contract, the lawyers, typically, or the project managers or the contract managers, whatever the case may be. They're into the terms of the deal. They're not into the dispute resolution because, of course, nobody at that point thinks there's ever going to be a dispute. Everybody's holding hands and it's the honeymoon and, so if you represent, for example, a corporation, you want to get your arbitration lawyer involved in the negotiation. So you don't just have a stock arbitration slapped in there. Better stock, clause than nothing. But certainly you can really make your arbitration more efficient if you think about the kinds of things that should go in there. Pick an arbitration attorney. A lot of people who litigate really know very little about arbitration. So there are people who are good at being arbitration lawyers, especially if you're like in an international arbitration, which involves all sorts of different issues. And then maybe number 3 might be the biggest one in my mind. Pick an arbitrator who's a project manager. Pick an arbitrator who just doesn't sit back and let the lawyers just do everything. Pick an arbitrator who feels they have an obligation to the concept of arbitration that the parties have agreed to engage in, so that they can manage the issues. They make the effort to address the things that are going to come up in the hearing, that keep people on schedule, etc. If you've got an arbitrator who knows something about the subject matter and the law, sometimes that can facilitate matters. Be prepared for the pre-hearing conference. The pre-hearing conference, is not just scheduling the date of the hearing. Many of us who do arbitrations have a laundry list of items that we send out beforehand, and we tell the counsel, you guys talk about this, or you men and women talk about this, because we're going to discuss these issues. And you come in there and you go through that laundry list of items. So those are all resolved early on in the process. And then at the hearing, use efficient techniques. Schedule a hearing for consecutive days. If you don't have consecutive days, it becomes a mess, and it can be spread out over months and months. Use witness statements, short direct, short cross-exam, teleconferencing, deposition transcript, any number of things. Expert hot tubbing. I'll get to that in just a second. That always, if you're not familiar with that phrase, you're expert hot tubbing. All right. Okay. And last but not least, and you'll see the last thing on or near the end of this thing is hot tubbing, the third from the bottom. Some of the recent topics that are sort of hot in the area of arbitration is the right of appeal. As you know, most arbitrations are binding. They're final. They're done. It's over with. That's one of the great advantages to arbitration. You take your chances. You roll the dice and put your best shot in. But now, some enterprising attorneys have said, okay, well, maybe we'll write in a right of appeal for certain kinds of issues. And most of the administrative agencies now have rules that provide for right of appeal if you choose to use them. Obviously, the advantages and disadvantages are fairly apparent. The disadvantages are the whole concept of a rapid, quick resolution in an arbitration has now gone by the wayside because you've built in a rather extensive appeal procedure. The other side of the coin is that, a lot of times parties just don't like that one shot. That's why parties oftentimes say we need 3 arbitrators, because if we only have one arbitrator, we're going to really roll the dice. By the way, I'm a big advocate of having one arbitrator when you can. It moves the process along dramatically, reduces the cost dramatically. Discovery is an issue in arbitration, of course. Discovery, I'll run into arbitration clauses occasionally that say the federal rules of civil procedure apply in this arbitration. Well, why didn't you just take it to federal court? You've basically made it the same. All of the rules of discovery, all the motion procedures, et cetera, have been made applicable. Internationally, our discovery was thought of pretty much as anathema until several years, just fairly recently. But now we're trying to hit sort of a balance between what can and can't be discovered. Most Europeans still think that our discovery rules are demonic. So if you get involved in an international arbitration, you're not going to get all the things you would get typically in the United States. Interim measures like preliminary injunctions, seizures of property. Now again, most administrative agencies like the AAA, JAMS, et cetera, have procedures now for so-called interim measures, because oftentimes you can have an arbitration by the time it's over with, the res is gone. there's nothing, or the purpose is done. So you've got to be able to stop certain activities. You've got to be perhaps seize property, that sort of thing. So there's a lot of movement in the field with regards to interim measures. Expedited procedures, almost all the arbitration agencies have now expedited procedures, faster procedures, so you can get through even quicker. Hot tubbing, by the way, for those of you who don't know, is basically where you get two experts on the stand, and they both make their presentation, and then they get to ask each other questions. And we're talking about opposing experts. So it's not this sort of, focused on one, and then we, a day later or 2 days later, we hear another, and then we go back, a day later for the other. They're sitting there and they're asking each other questions. Well, wait a minute, that's your position? What's that based on? Where do you get that from? And then the arbitrators get to ask questions, and the counsel get to ask questions. And you can resolve some of these expert decisions so much more effectively through these so-called hot tubbing procedures. A lot written on that recently, if you're interested. And then finally, a couple other things. As you may know, the TPP, the Trans-Pacific Partnership, not pipeline, partnership, right? Very controversial. A lot of people for it and against it who really don't know what it entails, frankly, but that's nothing new. But it's a bilateral investment treaty of sorts. That's what a BID is. These bilateral and multilateral investment treaties where a company can sue a government are starting to fall a little bit on hard times. Bolivia, Venezuela, and South Africa have opted out of theirs. It takes 5 years for it to become effective after you opt out of it. But a case fairly recently in South Africa almost bankrupted the country. So it's a tough area. And then finally, and the thing that was mentioned by Alan, arbitration as a market. Arbitrators, and this applies to mediators, arbitrators, mediators, ADR in general, becoming a bigger and bigger market all around the world. As a couple of people in here may know, a year ago I was on the island, the Republic of Mauritius, in the Indian Ocean, giving a month's worth of seminars. And there's two competing ADR agencies. There's the London Court of Arbitration and there's the Mauritius Chamber of Commerce. And they're competing with each other. They're both trying to create what they call a culture of ADR, which is a wonderful concept. Trying to teach the lawyers and the parties and the industries that there are other ways of resolving these issues. So you're seeing a spread of that internationally. Not only, of course, in the United States, and not only, of course, with issues like early mediation, which is a fabulous concept, but all over the world, you're seeing more and more of that. With that, I'll end early. Hopefully I didn't put anybody to sleep. Like I said, the drinks are free. There's food over there. We want you to pick up a ballot and vote for the officers. The officers you will be voting for are, we have that. I keep getting advertisements. Yeah, you're going to be voting for all of the executive committee, but in particular the chair, Adrian Wills, the chair-elect Courtney, the treasurer, Cortland Schaefer, and the secretary, Joanna Roth, who couldn't be with us tonight, as well as the other at-large members. Oh, and I mention one other thing. If any of you have any interest in joining our executive committee, don't hesitate to either get a hold of myself at the email I had up there before.
One of the working committees.
Yes, even more so. The working committees, yeah. If you don't want to, if you don't have time or have no interest in being on the executive committee, look at the website that we have and look at the committees that we have, because we do a lot of very good things in committee. That's where most of the work occurs, like Paul's legislative committee or Adrian's communications committee, to mention a couple. So please do that. And with that, I thank you all. And let's go have a bite to eat and a drink, perhaps. Thank you. One other thing, I did want to thank my executive board for all of the support they've given me over the years, over the last year, and I was a co-chair